Welcome back to the Supreme Petition on this historic night where Kenya's Supreme Court has become only the first bench in Africa to nullify a presidential election. Just learned the third in the whole world. Now we just want to get a recap of that ruling before we continue with the discussion here in studio.
The majority have not attempted to give any reasons in this short summary. But let me add this. Election is not an event. It is a process from the beginning to the end. We will, I believe, be able to demonstrate why we reached our conclusion that taking the totality of the entire exercise, we were satisfied that the election was not conducted in accordance with the dictates of the Constitution. Now, having heard from both sides, I want to read the final orders. Consequent upon the above findings, and as to what orders, declarations, and reliefs this court should grant, the following are the orders of the court pursuant to Article 142 and 3 of the Constitution and Rule 22 of the Supreme Court Presidential Election Rules. Number 1, a declaration is hereby issued that the presidential election held on 8th August 2017 was not conducted in accordance with the Constitution and the applicable law, rendering the declared results invalid, null, and void. Number 2, a declaration is hereby issued that the third respondent was not validly declared as the president-elect, and that the declaration is invalid, null, and void. Third, an order is hereby issued directing the first respondent to organize and conduct a fresh presidential election in strict conformity with the Constitution and the applicable election laws within 60 days of the determination under Article 143 of the Constitution. Regarding costs, each party shall bear its own costs. A detailed judgment containing the reasons for this decision and the dissent will be issued within 21 days of this determination in conformity with Rule 23.1 of the Supreme Court Presidential Election Rules 2017, as it is otherwise impossible with the limited time the court has to do so. It is so ordered.
All right, Chief Justice Maraga there, David Maraga, giving that precedent-setting ruling that is the subject of our discussion tonight. And ladies and gentlemen, I come to you, Felix. The CJ is saying very interesting things. First, that the election is not an event, it is a process. But also in the final order, they are saying that the IEBC should organize and conduct a fresh presidential election in strict conformity with the Constitution and applicable election laws within 60 days of this determination. And Mudomi, you weigh in, but I'll come to you, Felix, first. Strict conformity with the Constitution, does that mean anything? Is it as opposed to what?
Well, it is a confirmation of exactly what my sister Linda was saying a few minutes ago about the equality elections. And that is a debate that the entire continent has had, and more so in this country, as to what amounts to an election. Justice Maraga, for the record, was chairing the Judiciary Committee on Elections. There is no judge, or is one of the judges in this country who actually understands the electoral process. Election is not about election day activities. Election is a process, and therein lies the qualitative aspect of an election. And what the judge or the majority decision meant, and when they framed the issue number one for determination as to whether the election was done in strict conformity with the Constitution, and they made specific reference, Article 1, Article 2, Article 10, Article 38, Article 81, Article 86, Article 148, and Article 140. If you look at these chapters and these sections of the Constitution, they talk about quality elections. When you hear about an election that is free, fair, transparent, accountable, and verifiable, that is quality elections. When you see the Constitution of Kenya entrenches the political rights in the Constitution in Article 38, it speaks of the quality election.
But wasn't it the case Jubilee was making, yes, that, hey, we have the numbers here, so if you're going to challenge anything about those numbers, then you better prove that those numbers can be reversed by whatever irregularities or whatever problem you think the election had. That appeared to me, yes, to be the thrust of the argument. And yes, it sounds sensible that, hey, if Uhuru Kenyatta got 8.2 million votes, yes, and you're going to say that there was a problem in the election, is it not logical that you should prove that whatever problems you're saying existed actually would deny him, for instance, a 50% plus one, or would deny him a win altogether?
Let me tell you, that is the jurisprudence of 2013 elections. And in 2013, the issue for determination, which the Supreme Court sort of, it mixed all together, was the question of substantial illegality and substantial irregularities. In 2013, it was held that an illegality does not necessarily invalidate an election, and in 2017, the Supreme Court has vacated that decision, where they held, if an election is held substantially in a violation of the Constitution and the laws, then that election stands null and void, irrespective of the result. And I think they will elaborate on that when they give their reasoned judgment.
Mudhami, you had some interesting things to say about strict conformity, yes, with the Constitution. What is that?
Yes, Joe, for me, the misunderstandings we've heard about this process arise largely because of our failure. I always say Kenyans have a tendency to sign on documents they don't know what they mean. When we voted in that referendum in the year 2010 and said our elections shall be conducted in accordance with a system that is accurate, that is verifiable, that is correct. What many of us never understood is that these were not terms of art, and more specifically, for me, the misunderstanding has been the failure by most of us, lawyers, judges, citizens, to understand that actually all these attributes the Constitution gives our electoral system are absolute attributes. Something is always either correct or incorrect. There are no degrees of correctness. So there is no gray area between correct and incorrect. Something is either verifiable or unverifiable. There are no degrees in between verifiable and unverifiable.
What does that mean in English?
So to verify simply means
verifiable.
Yes, it means we must be able to confirm from the audit that the numbers add up. And I think the other aspect which we need to realize is...
So that means if we got someone from another planet and gave them everything we used in the election, they should come up with the same result that...
Yes, it simply means, to use a language Kenyans might relate more closely to, when you do an audit, any financial audit, or when you do your balance sheet, we should be able to say that it balances and we account for all the assets and the liabilities. There should be no gaps. Once you do your balance sheet and it doesn't balance, and you saw the judge is asking, by way of example, if a voter only participates in one election and he has 5 extra ballots, where do they go? That is a question of accountability, about verifiability, about accuracy. You would expect a good answer would have been, by way of example, if you see the total number of, say, stray ballots, plus the total number of rejected and invalid ballots, if you add them up, they explain the discrepancy between, say, the presidential total votes in the presidential election and the others. Anything short of that can only mean that this election failed the test of correctness.
Yeah, let's look a little bit at the dissenting opinions. And Linda, before we even go into the subject matter or the content of what they were saying, but the fact that we had 2 judges dissenting and that they actually had time in court to go through a summary, at least, of their dissenting opinions, how significant is that or not?
Joe, I think this time around we can see a departure from 2013, where in 2013 we had a unanimous decision. 7 individuals who were seized of the same matter, looking at issues from a very, very close distance, and they arrived at the same decision, all of them. This time around, we have seen a situation where 4 judges ruled one way and 2 judges ruled the other, which I think is a really good thing, because there is merit, or there is something to be learned from the dissenting judgments that have been given. I think that dissenting judgments underscore very, very important things that ought not to be forgotten, even with the victory of those that have actually won.
Yeah.
So I still think that there are things in the dissenting judgments that ought to be looked at in building our electoral system going forward. So that's what I think the value of those judgments is.
Felix, what did you think about the opinions by Justice Ojwang and Justice Njokindongo?
Well, I respect their decision, but I completely disagree with their decision. And with all due respect to both the 2 judges, that is the reasoning of pre-2010. And it is the same reasoning that informed the petition that was lodged in 2013. And I have had the privilege of looking at both Justice Njokindungu's dissenting opinion, as well as Jackson Ojwang. Their reasoning was that and there is a reason that by and large supports the position that was taken by the IEBC lawyers and President Uhuru Kenyatta's lawyers, that the election was held, people turned up to vote, and the results, despite the various irregularities that may have been noted, the difference between the president-elect and Raila Odinga was like day and night, and that therefore the will of the people was respected. It makes no reference as to, one, the legality of the process, and that is what the majority decision is largely based in, that an election that is held substantially and in an illegal manner is invalid, regardless of the outcome.
So is that to confirm what James Orengo was saying, that the process is as important as the outcome? Because we seem to have focused a lot on the outcome in the past.
Exactly, and that is exactly what Judge Maraga said, that election is a process, not an event. The popular view in Africa, and indeed in this country, is that an election is like a checklist. Once you hold it, then regardless of what the process was, then the result should stand. Now, when Judge Maraga made that point, and he said that they will elaborate on it, I think, and he said that they actually looked at the totality of the electoral process, and that means from the development of those laws, the procurement by IEBC, the various petitions, including the Maina Kiai case, and the political party nomination, the voting day activities, and most fundamentally, the results, the manner in which we handle the results. And the question here is, and the test, what happens when a voter casts his ballot and the results are declared? And they say they'll give it in totality.
Okay, we will 30 seconds, the call, because we need to take a break for the news updates, and we'll come back and continue this conversation.
I think the issue is not whether these judges dissent or whatever, but the explanations they give for it and the lessons we learn for it. For me, the lesson is that judging is not an exercise in precision sciences, and therefore it is an open textured process. It also shows the other important lesson I picked. If you see the decorum with which the majority and the minority treat each other, I think it's a useful lesson to be learned in this country, that just because we disagree, we don't have to abuse each other, we don't have to insult each other, we don't have to fight.
All right. Thank you very much, ladies and gentlemen. We have to end it there for now because my colleague Betty Kiallo is coming up next with a news bulletin just to let us know what has happened throughout the day. We'll be back later on within that hour.